So they sent you because you're from Rutland, a different county.
Yep.
And who made that decision?
I don't know. It's above my pay grade.
It was alcohol in the breath.
Okay.
And alleged slurred speech.
Which are enough indicators to request evidentiary test. Well,
Ryan doesn't know how to apply discretion. And
ma'am,
he didn't go to his...
I'm not gonna argue with you about it.
So I'm not going to answer questions. You don't need to read them to me.
I'm going to read this whole thing to you.
I know.
Because I need to.
Suspension. I get it.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re Eva Vekos, case number 26 AP 081. Representing the petitioner, the Office of Disciplinary Counsel, is Attorney John Alexander. Representing the respondent, Eva Vekos, is Attorney David Slay.
Good afternoon, counsel. We'll hear from Disciplinary Counsel first. Please start by introducing yourself, identify your client, and then proceed.
Good afternoon. John Alexander, Disciplinary Counsel, representing the petitioner, Office of Disciplinary Counsel. Thank you. May it please the court. The question presented by the petition for interim suspension before the court is whether the December 2025 misdemeanor criminal conviction of the respondent, State's Attorney Eva Vekos, for driving under the influence, first offense, is in violation of 23 VSA 1201A2, constitutes a quote-unquote serious crime as defined under Rule 21 of the court's Administrative Order 9. It is our contention that respondent's DUI conviction does constitute a serious crime as that term is defined under Rule 21, because the state's attorney's criminal conduct, in light of the circumstances surrounding its commission, reflects adversely on respondent's fitness to practice law as a criminal prosecutor in respects other than her honesty or trustworthiness. Specifically, respondent's pattern of criminal and other professional misconduct on the night of January 25th, 2024 reflects adversely to an attorney's fitness to practice law as honesty or trustworthiness.
Well, she wasn't charged with a felony, right? There's no felony here.
That is correct, Chief Justice. She was charged with and convicted of a misdemeanor, that is driving under the influence first offense. The petition certainly does not contend that any first-time misdemeanor criminal offense reflects adversely on fitness to practice law. Rather, the nature of this misdemeanor criminal defense and perhaps just as importantly, the surrounding circumstances, the aggravating circumstances of its commission and the aftermath indicate that State's Attorney Vekos is indifferent to her legal obligations and lacks the characteristics needed for law practice, specifically as a criminal prosecutor.
Counsel, how far out is the net that you're casting? Because it's alleged that there were certain statements made several days after the event. Are you intending to rely on those as part of your theory here that this is a serious crime?
I believe what the justice alludes to is State's Attorney Vekos' email correspondence, I think about a week after the night of her arrest. She indicated to law enforcement leaders in Addison County that she did not feel safe around law enforcement and therefore would not be meeting in person with them, would not be doing scheduled trainings. I offered that factual circumstance as really corroborative proof for the validity of what I contend was a very thinly veiled threat made on the night of her arrest in the processing room of the New Haven Barracks to Sergeant Neary, in which she indicated that this, by which she meant her arrest and imminent citation for DUI, was going to damage her office's relationship with local law enforcement. To more directly address the justice's question, I'm not casting a wide net. I'm not trying to look at alleged conduct that has no relation at all to the criminal conviction. What the authorities seem to indicate, both within Vermont and outside of Vermont, for certain criminal offenses, it is not sufficient to consider the criminal conviction in the abstract or in a factual vacuum. Rather, for certain criminal offenses that may or may not adversely affect on fitness to practice law, the tribunal must look to the surrounding circumstances. And it's our contention that one of the most important surrounding circumstances is how State's Attorney Vekos reacted on the night of her arrest in her interactions with law enforcement personnel. It's quite apparent that State's Attorney Vekos was making a plea for leniency, but linking that plea for leniency to her status and position as the chief law enforcement officer of Addison County. And that in itself is an independent ethical violation.
Related to this, Attorney Alexander, do you think that there is a different standard or a different body of case law that should apply when a prosecutor or another public servant commits a crime? Do you think that the analysis of what is a serious crime, reflecting adversely on the fitness to practice, do you think the threshold is lower when a prosecutor is involved?
I do, Justice Nolan, because just to the point I was making earlier, that when assessing whether certain crimes committed by lawyers are serious crimes, one must look at the relevant surrounding circumstances. And the authorities from outside Vermont, including the In re Oliver case from Indiana, indicates that one relevant factor is the attorney in question's area of legal practice. And it cites as a specific example, there was a Indiana prosecutor who was convicted of domestic battery on his wife. And the case cited there said, well, given that the prosecutor has been convicted of domestic battery, it raises a very reasonable question as to whether that prosecutor can zealously prosecute domestic assault cases.
I saw that case, but I noticed that there are some listed offenses that clearly qualify, and violence is one of them. But do you have a case? I looked at a lot of the cases. Do you have a case where it's a single first-time misdemeanor DUI with all conditions complied with, including alcohol programming, no recidivism or prior offenses, anywhere where interim suspension was granted for such an offense?
I do not, Justice Nolan. The case presented here is, in certain respects, unique. The People v. Miller decision from Colorado, that was a first-time misdemeanor DUI conviction, I believe, although the majority opinion cited some additional aggravating circumstances that it believed made not interim suspension, but basically finding a violation of Rule of Professional Conduct 8.4b for a serious crime.
Mr. Alexander, following up on Justice Eaton's question, when you talk about the aggravating factors, you're specifically referring to abuse of authority, correct? More or less, as you identified, the primary law enforcement officer, in the course of an investigation in her role as the state's attorney, she attempted to use her authority to get leniency or a better result for the DUI.
Yes, Justice Wapel. Those are two of the most important aggravating surrounding circumstances. The fact that in trying to evade responsibility for her criminal conduct of DUI, she attempted to leverage public position as state's attorney to gain leniency. I think there's also indications in Sergeant Neary's affidavit and the video from the processing room that it was almost as if State's Attorney Vekos was purporting to give Sergeant Neary legal advice, illegal guidance on, well, do you know that you can use discretion to simply turn a blind eye to all this? In my contention, that is a highly, highly aggravating circumstance directly related to the criminal conviction, that she's trying to evade citation and prosecution by leveraging her public position as state's attorney, as well as her professional status as an attorney who can give legal advice and legal guidance.
And then 1 week later, she then sent an email where she told the major primary law enforcement officers in the county that she was fearful of her safety a week later. And she couldn't work with them. Is that right? That she could not work with them?
That was the implication of her emails. I should note in complete fairness that State's Attorney Vekos apologized fairly soon after making these statements that I don't feel safe around law enforcement and I can't do these trainings. Looking to her conduct 6 days later, normally I would not do that because it's sort of removed in time and connection to the actual criminal conduct, but it sort of corroborates the threat she made in the processing room on the night of her arrest to Sergeant Neary that, well, this is really going to damage my office and its relationship with law enforcement. So it was a direct allusion to the fact that she controls the Addison County State's Attorney's Office, implying that she would use that authority to sort of retaliate or to try to get leniency for herself in a personal criminal matter. Unlike many other attorneys who are convicted of crimes, State's Attorney Vekos committed her crime directly in the course of her work as a lawyer, knowing, I would say, that a prosecutor who conducts a walkthrough of a crime scene has to have a clear head to do their job effectively.
Let me ask about that. Do you take the position that a prosecutor is always on duty?
Potentially, yes. Now, I should be clear. It's certainly not a crime where a disciplinary violation for anyone, including a prosecutor, to have an alcoholic beverage with dinner, if they're under the impression that they're not going to have to work later. I think the problem here was that after having that drink, State's Attorney Vekos was apparently contacted by the state police and told, we need you to come back to this potential crime scene. And then she had a decision to make. And the decision she made reflects very, very poorly on her professional judgment. She could have, I don't know if it would have worked. She could have tried to postpone the walkthrough. She could have delegated to one of her deputy state's attorneys. She chose to go herself, even though she knew and publicly volunteered in the press any influence at all from alcohol or drugs in relation to driving is a crime. So
Well, she said that in relation to explaining why she wanted to divert cases like her own, like DUI ones, instead of, she was talking about her platform of wanting to give leniency to DUI ones through diversion. Right?
Yes, that is correct. And that's certainly a reasonable position, I suppose, for a criminal prosecutor, an elected criminal prosecutor to take. But we're now in a completely different situation where when State's Attorney Vekos stands up before a judge or a jury in a DUI case, the question has to be asked in light of her criminal conviction for DUI, can she command credibility and respect from the jury, from the judge, from her fellow attorneys, and from law enforcement? And so that's certainly a relevant factor in terms of assessing whether this criminal conviction of this particular attorney reflects adversely on her fitness to practice law as a prosecutor.
Rule 8.4 makes reference, which I think everybody is using as sort of some of the case law under 8.4 as persuasive authority. And that rule talks about characteristics relevant to the practice of law and the comment. What characteristics do you think she lacks? What characteristics would you name that she doesn't have for the practice of law?
Her conduct indicates that she lacks perhaps the most important characteristic for a lawyer, which is a willingness to abide by the law, uphold the law, refrain from criminal conduct.
But then every crime a prosecutor commits will qualify then. Is that your position?
Not necessarily. It depends on the crime and it depends on the surrounding circumstances. Now, for example, if State's Attorney Vekos had been arrested on suspicion of DUI, and if she had said, well, I maintain my innocence, but I'm going to let the legal process take its course. I'm not going to try to improperly influence two different state police officers and say, well, you could let me go, or you could call a friend to drive me home. She could have decided to in no way allude to her official position and the office that she runs and what effect her personal arrest will have on the relationship between that office and law enforcement. If she had chosen differently, it's quite possible this petition would not be presented. If it were simply a first-time misdemeanor DUI where there was no aggravating circumstances, no pattern of misconduct that would indicate her indifference to legal obligation.
Mr. Alexander, can I ask a question? Let's suppose I agree with you that she committed this offense while she was in the practice of law, engaged in her duties as a state's attorney, that she tried to improperly talk her way out of getting charged, and that she then confirmed a few days later that it had impacted her ability to practice law in the form of the "I don't feel safe" email. Let's assume I agree with you on all of those scores, and as a result conclude that this is a serious crime as defined in the rules. Let's also assume that she abides by her conditions of probation and that in 3 months or so, her suspended sentence is up. Will she still be convicted of the offense in 3 months?
Well,
and should we be considering that today?
Well, Justice Drescher, that's a fascinating question. In part, I think it raised the separation of powers concerns, whether the statute dealing with expungement of deferred sentences, but I believe it's 13 VSA 7041. So that raises the question of whether a statute can somehow override or interfere with this court's plenary power to regulate the profession of law. But I think it's an interesting question that the court need not reach because as of today, State's Attorney Vekos is convicted of a crime. It's our contention it's a serious crime, and that triggers interim suspension under Rule 21. I think also it might be a bit speculative to talk about what might or might not happen in terms of expungement of the criminal conviction. Under Section 704(1), the presiding court, the Superior Court, could find good cause not to expunge. And I think an argument could be made that good cause would be furnished by the fact that it's an attorney who's convicted of the crime, and that criminal conviction under this court's rules is relevant to discipline and interim suspension. Again, as I said, it's just a question that I don't think needs to be addressed to decide this petition. She is today convicted of a crime. It's a serious crime, and that warrants interim suspension.
Okay, let's turn to the Respondent's Counsel. Please start by introducing yourself and your client, and then proceed.
My name is David Slay. I represent Addison County State's Attorney Eva Vekos. I have really three points that I want to make. One, first time DWI, no accident, no injury, no property damage, no observed driving errata, does not constitute a serious crime, no matter how you look at it. It's not a felony. It's not of that group that we used to call crimes of moral turpitude. It's not a crime in and of itself that involves an interference with the administration of justice. Rule 8.4b, in order to qualify under the interference with administrative justice provision, the crime itself must have an element of which involves interference with the administration of justice. DWI clearly does not. So one, I'm going to argue that it's not a serious crime. Secondly, I'm going to argue today that even if it is a serious crime, if this court determines that the circumstances indicate that a sanction will not likely involve any interruption of Ms. Vekos's ability to practice. Every single case that Mr. Alexander cited that applied to prosecutors wound up with a public reprimand as the only sanction. So to suspend her ability to practice law between now and whenever he decides to file a complaint before the PRB and after that process is over is simply going above and beyond what the end result would ultimately be.
Mr. Slate, can I ask you about that? Doesn't the rule state we shall order the suspension if we conclude the conviction is for a serious crime?
It may. I have to go look at it again.
Assuming it does, how would we ever get discretion not to impose that suspension if we conclude that in these circumstances it's a serious crime?
Well, I assume that you have plenary power to do justice in your supervision of the lawyers under your command. And if it seemed that it would be a miscarriage of justice to suspend somebody's license when you know that the sanction's not going to involve a suspension, would be consistent with that authority.
But wouldn't that be prejudging what the ultimate sanction is going to be in light of, the several aggravating circumstances that Mr. Alexander has pointed out?
Well, I want to get into that because I think one of the third part of my argument is that this particular request for interim suspension is both tardy and premature, so that if there had been concerns that the conduct was such that the public's confidence, the court's confidence in Ms. Vekos' ability to practice was implicated by her conduct 2 years ago, that the request to suspend her license should have been brought closer in time.
Closer in time to the guilty plea or the adjudication of guilt?
Closer in time to the conduct.
We're here because of the conviction.
We're here because she's alleged to have committed a serious crime with attendant conduct that is said to aggravate her criminal conduct. So if the allegation is that she was somehow improperly trying to evade criminal responsibility by throwing her office around to intimidate police officers not to charge her, that's the conduct that I seem to see here is most worrisome to Mr. Alexander, that an allegation to suspend her petition to suspend her license should have been filed then. Now, I also think it's premature because for the very reason that you've suggested, that how do we speculate about what sanction's going to be? If you look at every case that Mr. Alexander cited involving prosecutors convicted of DWI, no one got more than a reprimand. So assuming that we look to outside authority to justify his various claims, that same authority would suggest that sanctions is a public reprimand. I'm troubled by this proceeding because it's sort of quasi-evidentiary. It seems to me that if you watch the videos, and I have some indication that there were members of the court that wanted to see those, it doesn't seem to me that it's credible to say that Ms. Vekos was making a full-throated attempt to evade prosecution by asserting the sort of power of her office. She is.
Do you have any objection to us watching those videos, Attorney Slay? Do you have any objection to us watching this?
The short answer is probably not, but that's what I'm trying to get at. Typically, what happens in a situation like this is there's a complaint filed alleging that a lawyer has violated the rules of professional responsibility. That is sent to a hearing panel. There's discovery, there's evidence, there's ability to cross-examine, there's ability to argue about what the impact of various aspects of the case were. The hearing panel deliberates, they make factual findings, there's a sanctions hearing, they make a recommendation, and this court gets a full factual record. What's happening here is you get told that you tried to get Ryan Anthony not to prosecute her in a full-throated, emotional, heavy-handed way. If you look at the video, Ryan Anthony, Trooper Anthony, approaches even the driver's side. She hasn't driven away or anything. He says to her, look, we've detected odor of alcohol in your breath. Would you please step out of the vehicle? And she says something to the effect, oh, come on, Ryan, can you just have somebody give me a ride home if you're concerned? That is not a full-throated demand for leniency. That's like saying, hey, look, I don't think I'm impaired, but why don't there's a way to resolve this if you're concerned. Later on, if you watch the full 45-minute interaction with Sergeant Neary, who does the processing, she says, looks like she's upset, emotionally upset, might be crying. Says, this is going to cause trouble for my office and law enforcement. Well, it's pretty obvious it's going to cause trouble for her office and law enforcement. She's a state's attorney. She's going to get prosecuted for DUI. Is that some kind of corrupt attempt to obstruct justice? I would argue not. I would say that if we had a chance to present this evidence in an evidentiary hearing following the rules of evidence with an impartial panel, the conclusions that Mr. Alexander are recommending would not be persuasive. And so what we've got here is this.
Can I jump in? I just want to understand, are you conceding that your client, as she was being processed, expressed concerns about the consequences of what was happening with regard to the future relationship between her office and law enforcement?
I wouldn't paint it that broadly. We have transcripts. I'm happy to send it to you. You can read the very words yourself. But she says something to the effect, this is going to be problematic. That's true.
And problematic in what sense? What did she mean?
I think there's any different ways to argue that. I don't have the transcript right in front of me, but it's something like this is going to be problematic for me going forward.
Because she was the state's attorney?
Oh, yeah, of course, right?
So how is that not relying on her position as state's attorney to try to affect what was going on?
She's not trying to persuade him not to do anything. She's stating a fact that this arrest is going to have ramifications, right? The prosecutor's getting arrested. If she stayed silent, everyone would have to acknowledge that's true, right? This is a tricky situation.
What about her comment that she doesn't trust the police anymore?
Made 6 days later? Yeah. I think that was problematic. She was still upset. As you can recall, the last time we were here, when her license was suspended, she had to take a short leave. I mean, this is traumatizing. But look what she's done since, and then we get to the sanctions part. I mean, she gave Mr. Alexander every aspect of her entire lifetime, medical records, mental health records, counseling records. She admitted to the civil suspension, saying that the choice she made not to take the test which was her right, had consequences. Her driver's license was suspended. She completed the impaired driver's rehabilitation program and the attendant counseling sessions. She's executed her duties as the state's attorney in the intervening 2 years since her license was reinstated. I mean, again, that gets to where the sanctions are going to be.
Right, but does that, I don't think any of that pertains to whether it's a serious crime. I mean, I'm focusing on what happened in January of 24.
It's not a serious crime. It's not a felony. It's not a crime of moral turpitude. It did not affect the administration of justice. The Oliver case that Mr. Alexander relies on found that the DWI conviction of that prosecutor did not go to the fitness of that prosecutor's ability to practice law. And there's no showing in the interim, factual showing that this arrest had had any adverse impact on Ms. Vekos's execution of her duties as a prosecutor.
All right. Anything more, Mr. Slave?
No, Your Honor, but we would like an opportunity before there's any sanction imposed to have a complaint filed, to have it referred to a panel, to have the due process necessary to actually litigate whether these utterances were, in fact, illegitimate attempts to avoid prosecution. My view, if you look at those utterances, is that the conclusion is that they were not. And I don't think it's in this sort of quasi-evidentiary proceeding where, in essence, this is like a Rule 5 proceeding where it appears the court is willing to take Mr. Alexander's assertions in the light most favorable to the state and exclude any modifying evidence. We don't have a chance to put on a defense here. It's not a serious crime on its face. There should not be an interim suspension.
Okay.
Mr. Chief Justice?
Yeah, please. Yeah.
Thank you. I just wanted to apologize to Attorneys Slay and Alexander. I was losing connectivity, so I did choose to turn off my camera. I have been present throughout the entire proceedings.
Thank you, Justice Waples. Mr. Alexander, anything more?
Thank you, Mr. Chief Justice. If the court were able to indulge me, I had to address a few of the points made in Respondent's presentation. But I don't, if the court already has enough for today, I'm happy to simply request an order of interim suspension and leave it at that.
Well, I'll leave it up to you. If you have something more to say, please go ahead.
Well, I would make a few points. That sort of one point made by Respondent's counsel was that speculation on the possible or likely sanction in the future in a disciplinary proceeding before a hearing panel of the PRB. And that, just under the plain language of Rule 21, is not a relevant consideration in determining whether State's Attorney Vekos was convicted of a serious crime. If the court wanted to be a pertinent consideration, it would have written the rule differently. I don't want to get too much into the analysis of sanctions because I think it is premature, but suffice it to say, I do think that this will ultimately, when a hearing panel looks at the totality of State's Attorney Vekos's professional misconduct, it will not give her a mere reprimand. It will be a suspension. Another point to make, and perhaps it's an obvious one, is that an order of interim suspension is not a sanction. It's not a punishment. It's merely an order to essentially protect the public. Well, really, when one looks at the text of Rule 21, unlike the Rule 22, which provides for interim suspension based on threat of harm, Rule 21 does not condition the issuance of an order of interim suspension in any way on harm to the public. It's really more premised simply, was it a serious crime or not? And so I think that Respondent's counsel is really objecting to the process rather than sort of the merits of whether or not this is or is not a serious crime.
Okay. Any questions from the panel? Any remaining questions? Then please call a conclusion of the hearing.